Hello and welcome to Lunchtime Politics on Channels Television. I'm Millicent Walker. On the news this hour, House of Representatives considering 2 weeks recess over issues of coronavirus and what the lawmakers describe as porous nature of the National Assembly. Governor of Imo State, Hope Uzodimma, extends olive branch to his opponent after Supreme Court strikes out application by Ms. Ehedioha and the PDP. And the Amotekun bill has been passed in several states of the Southwest, giving the region's security initiative a huge boost in its quest for legal backing. Welcome everyone to the program. Let's start the show off with plans of lawmakers in the House of Representatives to suspend plenary for 2 weeks. The lawmakers say that it won't be a bad idea as it will enable the National Assembly management to put measures in place against the coronavirus. The decision of the House follows a motion of urgent public importance by Representative Unyime Idem on the need for the immediate action to prevent any new case of the virus.
That this House should suspend plenary for a period of 2 weeks or thereabout for the purpose of certifying everybody and also allowing management to put measures in place so that all of us can be tested.
Well, when we brought you that report yesterday, our correspondent Terry Kumi told us that no date had been fixed for the suspension. But let's get a feel of what's happening right now at the National Assembly. Our correspondent Linda Akibe is live for us. Linda, what can you tell us about the dates that has been decided for plenary to be suspended? All right, we might have to come back to our correspondent Linda Akibe on that story. But let's move on to another issue, and that is the outcome of what transpired in the hallowed chamber of the Supreme Court, which decision is final. That's the verdict of the court yesterday. It declared that its January 14th judgment on the Imo State governorship election is final. In a split decision, 6-1, the Supreme Court dismissed Ms. Emeka Ehedioha's application seeking a review of the judgment which removed him as governor of Imo State. The 7-man panel of the Apex Court, led by Chief Justice of Nigeria, Justice Tanka Mohammed, described the application by Ms. Ehedioha as an invitation to sit on appeal over its judgment. For Governor Hope Uzodimma, whose victory was again reaffirmed by the Apex Court, is offering an olive branch to his opponent. Senator Uzodimma believes the position of the Supreme Court reflects the true feelings of the people of Imo State who voted him during the March 9th, 2019 governorship elections. He commends the judiciary for standing by the truth while promising that his administration will continue to deliver good governance and prosperity to the people of the state.
And the mandate of our people, that will give glory to God, that at the end of the day, truth came out. And we commend the wisdom of the Supreme Court in standing by the truth. We dedicate the victory to Almighty God, and it is my hope that God will give me the wherewithal, the wisdom and knowledge to do that which He will take glory. Amen. So I invite all Imo citizens, sons and daughters, home and abroad, to come. Let us team up to take our state to the next level. Well, in this business, you must eschew the spirit of sportsmanship. It's not every time you win. It's also not every time you lose. When you win, you carry the losers along. When you lose, you follow those who won. So my advice to them is to come and bring the ideas. Let us team up, create a signage that will develop Imo State and bring succor to our people.
Well, there are more commendations for the Supreme Court over its judgment yesterday, this time from the ruling All Progressives Congress, APC. The national chairman of the party, Mr. Adams Ashomole, says the judgment affirmed that the choice of the people of Imo State has been respected. He made the comments shortly after the Supreme Court dismissed Ms. Ehedioha's application.
I do not think that what has happened today was strange. We know that Ehedioha did not have the required number. And that is a fact that nobody has ever disputed. How anybody thought he can impose someone who did not meet the spread is only known to PDP because they are specialized in rigging and they see rigging as their birthright. And that is why they could have the guts to be protesting to foreign embassies as if Nigeria is a colony under the supervision of some foreign powers. So I think what the Supreme Court has done today for me is just to reaffirm that they are the supreme. They are supreme, and whatever they did last time was on the basis of what was before them. They did not make mistake. There are no gaps. There are no ambiguity, and therefore there was no basis to reapproach them to sit on appeal in their own judgment.
For the main opposition, People's Democratic Party, the judgment yesterday is a disconcerting endorsement of electoral fraud, which places a huge burden on the court and the Lord Justices. The party notes that in the face of the sad verdict, Justice Chima Nweze's judgment presents a glimpse of hope for the nation's judiciary, noting that the party abides completely by every word of the judgment of Justice Nweze as treated facts which are truly sacred. The party's position is contained in a statement saying that it is indeed unfortunate that the Supreme Court had the wholesome opportunity to redeem itself and correct its errors, but chose to hide behind technicality to justify and endorse an electoral fraud. What Nigerians expected of the Supreme Court since the error in its earlier judgment had been fully established was to summon the courage to affirm its infallibility by correcting the errors and handing over victory to the rightful winner. Sadly, it failed to do so. The party says the judgment will continue to haunt the Supreme Court, as according to the party, it has created a burden of precedent and fallibility on the court. Well, let's now discuss the ramifications of the Supreme Court verdict and the implications. We have joining us one in Abuja, a legal practitioner, Mr. Jason Nwosu, that's in our Abuja studios, while in Lagos we have joining us Mr. Matthias Emeribe. But just before we get into the discussion, especially about the Supreme Court judgment, let's take you back to our first story, and that is we told you the plans of lawmakers in the House of Representatives to suspend plenary for 2 weeks. I believe we have our correspondent Linda Kibe for us at the National Assembly. Linda, what can you tell us as to when they will be suspending plenary for this 2 weeks?
Hi, Millicent. Now, but the House of Representatives is presently sitting. The same thing is also going on in the Senate. Plenary session is ongoing in the Senate. A day after the Senate leadership and some lawmakers met with the Minister of Health to discuss strategies put in place by the federal government in curtailing the spread of coronavirus. Now, so far at plenary, attention is not on the coronavirus. Rather, lawmakers have debated the security situation in the country. At this point, it's almost a given that security issues will be brought up at least once a week during plenary in the Senate in response to the security climate in the country. Now, this time, a lawmaker, Senator Emmanuel Bwacha, is bringing before the Senate an incident involving officials of the Federal Ministry of Works recently who were attacked on an assignment at the Tonga Maraba Road in Taraba State. Now, he's reminding the Senate to look at this issue, and then he's also reminded the Senate about the work being done by its ad hoc committee on the review of the security situation in the country, maintaining that the report that is expected from this ad hoc committee is of utmost importance at this time in the country. Now, a debate is presently ongoing as we speak on an interesting bill, and it's a bill being sponsored by Senator Abubakar Kyari, which seeks to establish a national commission, a National Offences Commission on the Electoral Act. That's the National Electoral Offences Commission. Now, Senator Kyari says this bill is really important and necessary at this time because INEC lacks the capacity to prosecute electoral offenders. He says that this bill, if passed to law, will address the problems of electoral rigging and electoral violence during elections, and also waste of resources by INEC. Now, the bill prescribes different jail terms for electoral offenders ranging from 10 to 15 years. So far, the bill is being supported by lawmakers across party lines, but we have lawmakers seeking for more clarification on the bill, and a distinction, to establish a distinction between this bill, that's the Electoral Offences Commission, and Electoral Tribunal. Now we'll bring you more details on the specifics of this bill in subsequent bulletins and other issues which may arise in the Senate. Back to you, Millicent.
Appreciate your time, indeed, Linda Kigwe, there for us at the National Assembly. Well, let's get back to our discussion, the Supreme Court verdict and its implications. We'd like to thank you once again, gentlemen, for talking to us. Let's start with you here in Lagos, Mr. Emeribe. According to Justice Ariwola of the spoke about the finality of the Supreme Court as being entrenched in the Constitution. So, according to the Justice, inherent powers of the court does not allow for it to review or set aside its own judgment. But were you satisfied with some of the pronouncements at the ruling yesterday?
Well, thank you very much. That is the majority view in this particular matter. Because before now, I'm not unmindful that the Supreme Court has not had time to review its own judgment. There have been cases where they've done that. And for all intents and purposes, if that were to be the case, I don't think one of the justices of the Supreme Court would have dissented, as it were, to say, no, there are times that this court has that inherent power to review its own judgment. But presently, the position has given in respect of this case, because every case is taken in line with its peculiarity. So in respect of this case, yes, the Supreme Court has said they are final and that is the end. But I know too well that there are many cases, or some cases, that the Supreme Court has gone back to review. They gave the final judgment, but they still went back and reviewed themselves. So if that is the case, like I said, the Supreme Court judgment will not be faulted based on singularly taking this particular case as its own, on its own merit. But in view of other cases that they've looked into, we may have cause to question or to raise question.
But those other cases, are they the same as this case?
They are not the same. Now, this is a political case, and I guess that could explain why the Supreme Court is, making this position, because the danger, with due respect, of very many other political cases that have gone by to be litigated will be very high if the Supreme Court perhaps give in to the application. And I guess that was basically what they had behind them. And for all intents and purposes, what interests me more in respect of this judgment is the fact that two things happened. One, the dissenting judgment and the refusal by the Supreme Court to award cost against the lawyers that came for the matter, unlike what you had in the Bayelsa case where cost was awarded. Now that simply will tell you that even the wise men there knew that this case is special. But because of the ripple effect, the danger that it probably will portend for our jurisprudence or for the legal system, as it were, they decided no. We will probably have opportunity when next time this matter will be dealt with.
Okay, we'll come back to continue with this. Also, we have Mr. Amos in Abuja. We'll hear from you when we return, but let's go on a break. We'll be talking to you more about the crisis rocking the party, talking about the APC as in Edo State. They have plans ahead of its membership and also enrollment program. Please join us again. Welcome back to the program. But first, let's bring you some of our stories in brief. We begin with the former Director General of the National Information Technology Development Agency, Mr. Peter Jack, who has been arraigned by the Office of the Attorney General of the Federation before an FCT High Court appeal over alleged 15 million naira contract scam. Mr. Jack, however, pleaded not guilty to the two-count charge of criminal breach of trust and cheating. The Defense Counsel, in an oral bail application, urged the court to grant the defendant bail on liberal terms on the ground that the offence is one that is bailable. Trial was adjourned to April 30 and May 18, 2020. Elsewhere, the Economic and Financial Crimes Commission, EFCC, presented another cheque of 263 million naira to Governor Abdulrahman Abdulrazak of Kwara State as part of the loots recovered from alleged corrupt officers in the state. According to the zonal coordinator of the anti-graft agency, the monies were looted from the state's treasury. Well, let's quickly find out from our correspondent who's covering the House of Representatives, Terry Kumi, on indeed the decisions the House are making at plenary as to coronavirus and indeed suspension of plenary. Terry.
Well, hello, Millicent. I'm sure some people are surprised that the House is sitting today, and that's because of reports yesterday that the House has suspended plenary for 2 weeks. But just a few clarifications on that. The House of Representatives resolved to suspend plenary. No date has been given for that yet. And that's probably why the minority leader was infuriated this morning when he raised the matter of privilege, I beg your pardon, because he was the one who moved that amendment yesterday for the House to suspend activities, for the National Assembly in general to suspend activities, to allow for members to check themselves and for the management of the National Assembly to put certain things in place. So yes, has the House resolved to suspend plenary? Yes. Has suspension been carried out? Not yet. But here's what the House is trying to do, trying to cover its end of the bargain, but that's not entirely the case. When the motion was moved, the main reason behind that motion was to allow for members to check themselves and to, allow management to put measures in place to forestall any form of the outbreak of the coronavirus in the National Assembly. But the House is trying to narrow it down to say that it is trying to suspend plenary to sensitize its constituents, which isn't entirely the case. And the minority leader did quote a daily this morning saying that that's not what he said, but he's actually on tape saying those exact words. Plenary commenced some minutes ago and not much has happened apart from that. But I can also tell you that most of the lawmakers did not even know that they would be sitting today. Some would say the new ones. So that's the kind of controversy that has happened so far in the House of Representatives. It's back to you.
Thank you so much, Erica. May we wait for the full report later in the day. Well, let's get back to our discussion, and that's the Supreme Court verdict on this issue. We've been talking to our guest in the studio here in Lagos, Mr. Emeribe Matthias, and also our Abuja studio. We have Mr. Jason Nwosu, both legal practitioners. Let's now find out from you, Mr. Nwosu. The PDP called the Supreme Court verdict, in their words, disconcerting endorsement of electoral fraud. Is that a view that you hold as well?
Of course not. I hold the view that the Supreme Court yesterday restated its resolve that its judgment decisions are final and appeal from it lies to nowhere. If you recall, in Diri and Leon, the Supreme Court said that the judgment of the Supreme Court is final and appeal from it lies to God and to no other person. So, not much was expected. I didn't expect that the Supreme Court would reverse itself yesterday. And true to it, they restated their resolve that they are final and their judgment is final for all times.
Mr. Nwosu, what's your take on
argument of the PDP?
What's your take on the dissenting voice now? Many people are saying perhaps something changed. What do you think changed for the justice, and that's Justice Chima Nweze? What's your take on his dissenting position on the judgment?
Well, for me, nothing changed. That's his personal opinion. The authorities he relied on are authorities of a foreign country, a Commonwealth law country. It does not have any bearing to our constitution or law. It's just persuasive. You get? So it is not based on our municipal law here. The reason given by the Supreme Court yesterday for reaffirming or restating its judgment is founded in our laws, in our municipal laws, in our local laws, in the Supreme Court Act and the rules. So I do not see the need for Nweze to dissent. Well, that is his opinion, and the lead judgment has carried the day.
All right, Mr. Emeribe, back to you here in Lagos. Looking at what he said, what's your view? And also, you mentioned there are certain cases the Supreme Court has reviewed a judgment or a decision it is given. Can you cite some of these cases?
In 2000, there's a case, Olorunfemi. I can't remember the name of, but in 2000, the court in that very case had cause to ask for a review or to allow a review to occur because the cross appeal of the respondents in that matter was not considered before judgment was given in respect of the main appeal. just like you have here. So the court had cause to say, go back and retry the matter. Now, in 2015, there's a case, they call it Jeff. It's a political case where the court, Supreme Court, although there they gave judgment in favor of a party that they told the party, go back. In fact, they asked INEC to conduct another election. They nullified the and asked INEC to conduct another election. The party had cause to go back before the Supreme Court. I said no. But that by virtue, because the Supreme Court by then was relying on the provision of section 142 and 141 of the Electoral Act as it's amended 2010. But when that other party came before the Supreme Court, it had cause to cite the Federal High Court judgment given by Justice Kolawole to say that those provisions that the Supreme Court is relying on no longer subsist. So to say, it has been struck down. And to that extent, the Supreme Court now ordered that a certificate of return be issued.
I must quickly ask, because we're running out of time. And, final question to you would be that has this case helped our electoral jurisprudence?
The Imo case? With due respect, it's a fundamental question which I think the Supreme Court ought to have answered. Because the judgment as given yesterday, as far as I'm concerned, will only help in only reaffirming the supremacy of the Supreme Court in respect of their judgment. But socially speaking, I don't think it will promote our electoral jurisprudence.
To you, Mr. Nwosu in Abuja, what do you think this judgment, the review and the position in Bayelsa and then Imo State does to our electoral jurisprudence moving forward?
Well, it have stated the fact that those political robbers, electoral robbers, who go and substitute election results for their own selfish end will no longer rule the country, will no longer have sway, will no longer succeed, because in the end, the Supreme Court is there to set the record straight and ensure that justice is done. Well, in reference to one of the authorities he cited, in Ibero and Onoha, the Supreme Court said that under any guise, they will never review its judgment. Review here, that in the judgment he cited, was for the purposes of correction and not for the purposes of changing the decision of the Supreme Court. So
we'd like to appreciate your time. I wish we had a lot of time. I wish we had time to talk more about this issue. But we'd like to thank you, Mr. Jason Nwosu, there in Abuja, and also here, Mr. Matthias Emeribe. Thank you for your thoughts on this issue. Finally, party politics with the governorship election in Edo State just around the corner. The All Progressives Congress in the state, they're saying it has already started housekeeping with an update of its register targeting members list 500,000, I believe. The Edo State governor was speaking at the Irua Township Hall in Edo Central, where he said the party is starting preparations with consultative meetings with leaders in all 3 senatorial districts. And finally, the Oyo State House of Assembly passed the bill establishing the State Security Network Agency, Amotekun, into law. The passage is coming after the presentation of the report of the House Committee on Security and Special Duties at plenary. Meanwhile, lawmakers in Osun, Ogun and Lagos States Houses of Assembly also deliberated on the bills establishing the security outfit in their various states. That's our program this afternoon. We'd like to thank you for watching. I'm Millicent Walker.